Hi everybody, you're very welcome back to Law Hero. My name is Jen. I make videos about the law. And today we're talking about the Fe1 Property Law from autumn 2023. So I'm just going to dive through. So the first question is a problem question, and I actually think it's potentially rather horrible because the mortgage was created here in 2008. So potentially we're talking about the pre-2009 Conveyancing Act 1881 provisions, which isn't great. You would look at the provisions of sale under section 19, the different requirements under section 19 for the power of sale, that notice of arrears have been issued. Usually this is 3 months being in default. Then notice has been issued in default continues for 2 months, and that there's a breach of the contractual provision, or if there's a breach of the contractual provisions by the mortgagor, which is the borrower, which is unrelated to payments. I don't know. Trying to think of something that would invalidate the mortgage. Not paying your life assurance, for example. And then section 20 then, so presuming you have one of those conditions of the 1881 Act, once the power of sale becomes exercisable, the mortgagee may sell the mortgage to a third party, and this frees up the mortgagor's equity of redemption. So yeah, I mean, again, this is not great question. I don't think a lot of people would have been prepared for the pre-2009 mortgage provisions. I obviously worked in that area, but even I wouldn't have been 100% sure of the provisions, simply because they were always written into the mortgage themselves, and we wouldn't have had to apply the law because it was the mortgage would have taken precedent, and the mortgage would have had the legal provisions in it, so it wasn't such a big thing. But yeah, the 1881 Act, that sucks. So another point I actually would mention is that the start mortgages issue, obviously the provisions of 2009 Act only applied to mortgages created after the 1st of December 2009, because there was a gap in the law, because section 62(7) of the registered property is just about the checking who the registered owner of the charge was. This was not substituted into the 2009 Act, which meant there was a lacuna, or there was a gap in the law, which meant that there was no means for banks to apply to a court for possession of registered property if the mortgage was entered into before the 1st of December 2009. So we assume here that the property was registered. It's an apartment, so probably was. And the start mortgages case left lenders in an extremely difficult position, as they could only obtain an order for possession of registered property where proceedings were instituted before the 1st of December 2009, which are not here, where repayment of the money came due before 2009, which wasn't here, and a demand had been made before 1st December 2009. So the LCA 2013 Act applies to mortgages that were created before the 1st of December 2009. Then everything else then is looked after by the 2009 Act. So I think it is important to say the LRA 2013 applies to pre-1st December 2009 Acts when you're looking for repossession proceedings. So Section 2 deals with cases where lenders have initiated a repossession proceeding in relation to the borrower's principal private residence, which we assume, and all actions for repossession for mortgages created before the 1st of December 2009 must be taken in the circuit court. Now, she also lost her job. So this means that the court might adjourn the proceedings for repossession up to 2 months to allow her to create a personal insolvency arrangement with her creditors under the Personal Insolvency Act. So that actually might be a better way for the bank to get their money back rather than taking her to court. Okay, complicated. That was a complicated question 1, even for a qualified solicitor. Okay, question 2 is a note on 4 unities which you need for joint tenancy. Unity of interest, title, time and possession. The right to a profit or pronged, which is to take something of economic value, the right to take something of economic value from the land of another and adjacent property, and comorientes when 2 people die simultaneously. And question 3 is the finder's question. I'm not going to go down through that because it's very, very straightforward and people usually do very well in it. Question 4 is an essay question to analyse the rules and principles which govern construction of wills. Again, most people would be very comfortable with that. And the second part then is dictate how an intestate's estate should be distributed. It's a little bit more nuanced there. When somebody dies intestate, you just have to go down through the rules of intestacy there for that second part. Question 5 is a problem question if you go down. It's another wills question. And it's about provision, legal. It's about the proper provision question. Question 6 is around contractual licenses, which I don't cover. Question 7 then is a problem question around adverse possession. Again, most people would have enjoyed that. Then question 8 is an essay question around critically evaluating the effects of right of way and the right to light, right to support, which are all types of easements and potential reform. Again, I think most people would have done well there. So all in all, other than question 1, I think that was a fine paper. Thank you for listening and I'll see you in the next one.